In a world where artificial intelligence, better known as AI, is increasingly becoming more prominent, boards will encounter several challenges when dealing with AI. One of these hurdles boards have to take is making sure they are aware of the legal implications of using AI. To assist board members in navigating the legal challenges posed by AI, we have invited an expert in the field, Peter van Dyck, from our partner ANO Shearman, to join us in the studio. Thank you very much for being here, Peter. Maybe you can introduce yourself and your company to the audience.
Absolutely, and first of all, thank you very much for inviting me to speak about a topic that's quite near and dear to my heart and that increasingly is becoming an important part of my daily practice as a lawyer as well. Maybe indeed to introduce myself first. So I'm Peter van Dyck, a partner heading what we call the IP and tech team at ANO Shearman in the Belgian office, where I focus now for, I think, must be bordering on 23 years now at ANO Shearman on anything dealing with IP and technology. And of course, lately, AI has been a very big part of that. We have an increasing number of clients who are integrating AI solutions, who are faced with a complex regulatory framework that I'm sure we'll talk about. So a lot of my day-to-day practice now is helping those clients navigate those legal challenges in AI.
Okay, yeah, that's quite interesting, and
I think
it's great
so.
that you're here then to help us, in explaining the challenges of AI. And if I understood it well, you at ANO Shearman you already use AI, so maybe you can start with that and explain how
Absolutely.
it works
Happy to. I mean, we advise on the legal aspects of AI, of course, but we also use it ourselves. And I think I'm a strong believer that any company really, but including law firms, need to engage with AI and experiment really with it to see what it can bring. And we were actually quite early on that. I think we must have been the first law firm to integrate ChatGPT 4. It's called Harvey. It's basically a legal assistant version based on ChatGPT 4. Back in January 23, where we basically rolled it out across all our lawyers, across all our offices over the world. Everybody had access to ChatGPT, and that was really way before ChatGPT really became a big hype. And since then, we've all tried a little bit how it works and how it can help us in our practice. I've actually found it very useful. I've also discovered limitations, and we can talk about things like hallucination. You know, Harvey, like any of these AI tools, they hallucinate, they give you, results that sound very real, but are just invented. At the same time, it's an extremely useful tool. If you need to draft things like a PowerPoint presentation, you just give a few keywords and out rolls a presentation that you'll have to adapt, but you've got a base that you can work on, which really is quite amazing. If you need to draft a contract, very often in the past, you kind of take your contracts that you've done in the past, you look at your 3-4 best examples, and you kind of take that, amend it a bit, and use that as a baseline. Now you can just ask this tool to give you 10 different versions of a clause. Again, you'll need to amend them, but you've got 10 usually quite good working examples that you can work on. So it just gives you such an access to information. So we've started using that quite actively, and if I look at my own practice, I'm probably, waiting about an hour, 2 hours a week, which doesn't sound like a huge amount of time, but multiply that by all our lawyers, it actually is quite a big shift. So yes, we've used it, and I'm quite intrigued by what it can bring.
Yeah. I think I agree with that, and we also use it at GUBERNA, and it can really help in being more efficient and.
I think so. At the same time, as I said, there's limitations to that, right? I remember very well one of the first times I used it for a legal research. So I basically asked it, well, give me some case law on this topic. And it came with 3 examples that were suspiciously close to what I was looking for. It was really smack on. And so I started looking into those. I didn't find those cases anywhere. And then I asked the tool, actually, can you give me the full text of these decisions, this case law? It gave me 10 pages of full text. That was all hallucinated. That was all invented. And I mean, you've seen those examples in the press of US lawyers, filing fake cases in their submissions. There's a risk. So we've got these very strong guidelines that for all our lawyers that use AI, it's kind of a co-pilot. You can use it can help you, but everybody needs to check, double check, triple check, whatever the output is, because otherwise there's too much risk involved.
And I don't know if I may ask that question, but do you already see that companies or your clients use the AI in the same way or even go further?
Yeah, absolutely. Absolutely. I mean, as I said, a large part of my daily practice these days is advising clients on AI. Of course, partly it's because there's such a hype, right? So everybody wants to do something with AI. But at the same time, there are genuine use cases that our clients are starting to implement. And it's across the boards. You know, as an IP and tech lawyer, you work for, companies in any type of sector. Of course, there's some tech players that we're advising, and they're developing the ChatGPT 5s of the world.
Yeah.
But then you've got all the other sectors as well. I mean, we do a lot of work for life science, healthcare companies. It's actually quite amazing, the research they can do, the analysis they can do on data that they gain, for instance, from clinical trials, to find correlations that otherwise would have remained undiscovered, that can then help to create medicines. So we see a lot of those clients using that. But you've got the same in HR, things like filtering CVs. You've got the same in the financial sector, fraud detection. I think there's almost no sector that cannot use AI to become more efficient to some extent.
Yeah. Yeah, I mean, if you talk already about these firms that analyze a lot of data, use it for fraud detection, then you immediately come with something that directors will interest. It's the risks linked to this, because I can imagine if you, say the AI will conduct all these tasks that are fundamental to our firm or to our operational to the operational aspect of the firm. There's a lot of risk involved. So what would you say about that, or what do you advise these people?
Yeah, no, that's indeed an important question. I mean, generally, I would first take a step back. There's certainly risks involved in AI, and there's frankly a lot of risks because it's all new, right?
Yeah.
At the same time, I think those risks are manageable, at least in the current state of mind, state of play. From a legal perspective, those risks are manageable. So, we advise a lot of clients on these risks, but I always try to find a way to advise, yes, you can do it if you arrange your solutions in way A, B, or C. So I think that's not any risk that for me are really a no-go or deal breaker. I think that's maybe a first kind of general point. But then if you look at the risks, there's a few legal risks, but there's a few more fundamental risks as well, I think. To me, if you look really at what fundamentally is the risk from board level discussion perspective on AI, I think hallucination is part of that. And there's some technical solutions, but nothing that really works foolproof. I think there's a risk of bias.
Yeah.
And I think that's a real risk, and once again, one where there's no clear answer to yet. Again, it's all about getting the data set as correct as possible. We'll talk, I'm sure, about the European AI Act. There's tons of provisions that try to deal with that risk of bias. But again, there's always going to be a remaining risk there. So I think bias is a real risk as well. But if you then go more to kind of my shop, the legal aspect, which of course is where I will come in. If you really look at the big risks, to me, and different people will give you a different answer to that, I think on the one hand, you've got regulatory compliance. And that's, I think, increasingly complex. Again, we'll speak about the European AI Act, which has been big news actually, and by the time this goes out, it will have entered into force. It's now been formally published as we speak. It, of course, adds a lot of obligations. It does add a lot of also cost to comply. The risk of non-compliance, given the huge fines that are possible, is also real and can have a real financial impact that hurts companies. But that in itself is not the tricky part yet. The tricky part becomes if you're a global company, you've got the European AI Act to deal with, but then you've got the US with a very different stance, the UK that's very liberal, Asian countries taking a different view. So how do you navigate that kind of complex spiderweb of compliance, of regulatory compliance? I think that to me, that's probably at the moment risk number one from a legal point of view. So that's something that is a board level discussion, I think, how you deal with that. think that the second board level discussion to me, and one that I've had to deal with a few cases where that went wrong, and I mean you've all read, I'm sure, in the press some other examples, is IP leakage. Yeah. I think that's a real risk, and that all comes down to awareness and training. But I've had to deal with a few companies where employees put data in that was, trade secret or, a patent that hadn't been published yet. So really data you don't want to get out of the company. That then becomes part of the input data because it was used in the public kind of ChatGPT version. The public AI becomes part of the input data, becomes part of the training data, and at least has a risk that it will be reflected in the output data to some extent. So I think IP leakage, if you really look at the big picture risks, that to me is really the second big risk that is board level that you need to wrap your head around.
Yeah. So would you then recommend to discuss it during board meetings on a regular basis every?
You need to. You need to. It's going so quickly. It's shifting so quickly, not just in terms of the technology. There's new technology coming out, new ways to deal with hallucination, ways to make your data private. There's always new technological evolutions. But then you've got the regulatory evolution as well, and all that happens in parallel. It's not just a moving target, it's multiple moving targets at the same time. So, I mean, this is not a discussion that you just need to leave to your external lawyers, not something to the in-house legal department or the compliance department. It needs to be discussed at board level. You need to bring all the different stakeholders together. I think that's really key in getting it right.
And would you say literally every firm, also those who just use ChatGPT a little bit, or would you really say only those big banks that use it? Or
well, I think, of course, I mean, the more you use AI, big banks will probably have more advanced AI, fraud detection, but also other AI systems, also in terms of marketing systems. So I think, of course, it's maybe potentially even more important for them to sit together regularly. But I think even smaller companies should, with some frequency, get together and discuss that, preferably at board level. I mean, the point you mentioned, if I can be a little bit controversial there, I mean, companies that use ChatGPT, I actually would probably not recommend any of my clients to do that. Because ChatGPT, it's a wonderful tool. Technologically, it's fantastic. But unless you buy the enterprise edition, I mean, it's really risky to just use the public version, because even though there are some options you can now toggle to keep your data more private, there's a real risk, I think, of IP leakage. Okay. So I think if you're a company using ChatGPT, that probably in itself would be a red flag to me. It can be done again, but there need to be a lot of awareness and I think training and rules around that to make that work. So yes, I think the short answer is every company benefits from regular discussions, and the bigger your company is, the more it engages with AI, the more that's going to be needed, of course.
Okay. And then you would also say that AI, it should be reflected in the minutes. Would you recommend this as well, or should it?
I think so, yes. I mean, and we can get into that more in detail also. It's also a question of responsibility, because it is quite complex spiderweb, as I said. Part of it is trying to be as compliant as you can, but frankly, it's very difficult to be 100% compliant, because a lot of these regulations, they're all new. So it's important to think about your steps, take them in good faith, and then document them as well. I mean, it's not enough to try to be compliant, but you need to document your compliance. And that starts with meeting minutes, I think. If you have a discussion on AI and you decide that certain use cases, for instance, are allowed, certain others are prohibited, you should document that so that you can have that handy and you've got the document ready if ever there would be an issue, non-compliance, investigation, that you can bring that to the fore.
What are this is maybe an interesting question for the audience, what are actually the risks for board members if something goes wrong?
It's the same as for anything else that goes wrong in a company. There's no specific liability hanging with AI. Again, that risk is manageable, but it all starts with I think, a good documentation. First, a good discussion and a good documentation. And what we still see with a number of companies is that the board is not sufficiently involved. And that's why I made that very strong statement that I think it should be really regularly on the agenda of the boards, because we often see it is still left to kind of the legal department often, or the data privacy lawyers. And they can do a lot of work, a lot of prep work, but I think it's important at these points that the really important strategic decisions such as which tools do you use, what use cases do you use it for. I think the board needs to be involved in that discussion.
And has there already been a litigation with regards to AI in Belgium or in the world?
Litigation in terms of board responsibility or
yeah, board responsibility. Yeah,
because there have been plenty of litigations in things like who owns the copyright in the output. So there's plenty of that. As far as I'm aware, actually, in terms of board responsibility, not yet. It will be coming, unfortunately. Hence why I made the point that boards should be well prepared. But as far as I'm aware, not yet, or at least nothing that I've been part of or that has been published.
Yeah, something we do not look forward to, but will be interesting nevertheless. Yeah.
As in all these things, you never want to be involved in a litigation, but of course, from a
especially not the first one.
Exactly. But from a lawyer's point of view, I think we're all waiting for some of these litigations because they will set the scene. They will make some of the rules. I mentioned IP litigation. There's quite a bit on copyright. Not so much in Belgium, but in other countries, the UK, US. I think the outcome of those, who owns the output of an AI system, all lawyers are looking at that. That will be a fascinating answer. So I think in terms of precedent case law, it will be an important period to see what comes out. But of course, as a company, better to try to avoid being part of that.
Yeah. And maybe with the new European Union AI Act will also play a role. Is this? Maybe you can explain very briefly when companies fall or will fall under this AI Act.
I'll try to keep that brief, but it's fortunately or unfortunately, it is a relatively complex question. Because the AI Act, maybe just taking a step back, and a lot of the listeners will have followed this, as I'm sure you have, it's been a long time in the making. It's been debated for a long time with very strong views from the different European institutions. And what's on the table today, and it has been published now, is very much a compromise. You see that in all areas, and very often the best way, or the easiest way at least, not the best, but the easiest way to get to a compromise is to leave things somewhat vague. Yeah. And that's what you see very much in the European AI Act, which of course from my point of view is a real pity, but there's a number of points that are unclear, where you will need litigations, where you will need guidance to clarify that. I'm saying this because the scope is part of those areas that are probably not entirely clear yet, but if you look at the general answer to that question, there's always a question when you fall within it from a material point of view, and then from a territorial point of view. If you look at the material scope, that really comes down to the question, what is an AI system that's governed by the European AI Act? And that's quite wide. The core of it is an AI system is basically any type of software that has a certain level of autonomy.
Which are quite a lot of
Which is
systems.
A huge amount of systems. It's not just the ChatGPTs of the world, it's actually quite wider than that. It's also unclear, and that's why I refer to the guidance, for instance, that's needed. What does a certain level of autonomy mean? How much autonomy is enough to put you over that threshold? The good thing is, initially, that qualifier level of autonomy wasn't in the definition, which meant that even in reading the strict if-then systems that are programmed by human, if X happens, then Y results, even those were qualified as AI systems. That's now taken out because that doesn't require any level of autonomy. So I think it's more limited than it initially was, but it still is a quite broad set of AI systems. There is a reference there to machine learning as well. But if you look at the text, it says those systems may exhibit a level of adaptiveness. May exhibit. So the may to me at least shows that it's not a requirement, it's a possibility. So a system does not necessarily need to have a machine learning component to qualify as an AI system. It's just all about that level of autonomy. So that's very wide, and that's the first material scope question. The second one, if you look territorially, and I'm sure a lot of listeners here will be companies that are Belgian, but there will be international companies as well that are listening into this. Frankly, it's again quite broad. Of course, whenever you use in Europe an AI system, or you're a provider, you provide it in Europe, all that is covered, that makes sense. But then there's this one provision that says, if you have an AI system that has been developed outside of Europe, it is used outside of Europe as well, but you're using the output of that system in Europe, that is enough to bring the system itself in scope of the AI Act. So think about it. That means you're a Japanese tech developer, you've developed an AI system, let's say a US company uses that Japanese AI system to, say, filter a bunch of CVs. And then the results of that filtering exercise are sent to the French affiliate of that US company. That is enough to bring the Japanese AI system in scope of the EU AI Act. That's enormous. And we've seen this in a number of these recent European rules, that the extraterritorial effect is actually quite extensive. So very wide scope is the big conclusion.
So there will be huge scope, and that will bring companies into problems, you think, and or should be discussed on board level? Which risks are involved?
I think so. I'm still speaking to a lot of clients, even though it's a decreasing number, that are assuming that they won't fall under the scope of the AI Act, either because they do a system that they don't qualify as a hardcore AI system, or they use it only outside of Europe. It's time and time again, and not always, but often the message will be that even though it might not be a hardcore AI system, or it's only used outside of Europe, it still will fall in the scope. So I think it's important on board level as well not to take assumptions that you're not covered, but to look always as a first question, what AI systems do we have, where do we use them, and is that covered by the scope of the European AI Act? Don't take assumptions. And again, that to me is a board level discussion, or at least it needs to be prepared by the legal team, but then reviewed and confirmed by the board.
Okay, yeah. And another part of the AI Act that was discussed pretty extensively were the risk levels described in the AI Act. Can you explain a little bit more about that?
Yeah, sure. So, I mean, that's really the core of the AI Act. And I think actually it's a pretty clever approach from the legislator on that point. Rather than to have one set of rules that apply to any type of AI system, they've defined a number of risk levels. Of course, there was a lot of debate what system falls into which risk level, but I think the core of it is there's 3 risk levels, and then there's a remainder category. So you've got, as a first risk level, systems that are simply prohibited. And those are systems where the European legislator, after all the discussions they had, came to the conclusion that they don't think that should be allowed in Europe.
Yeah.
And we can get into that, but those are really often quite extreme cases of systems.
Autonomous killing, drones, that kind
For instance, systems those are really systems that kind of exploit people, manipulate people. I mean, there's some examples there of systems, if you interpret them widely, that may be a bit broader. For instance, one that jumps to mind, one of the prohibited AI systems is, for instance, a system that recognizes emotion in the workplace. So say you arrive at your PC and your PC monitors through your camera, your mood and says, well, you look a little bit down today. You need to be productive and be happy. So please, here's a nice movie and be better after that. That's going to be a prohibited system.
Okay. Yeah.
And that sounds a bit broaderish, of course, but those systems exist in certain parts of the world and are implemented in a number of companies. So there's some that could be realistic examples, I think, for companies, but the vast majority are indeed the extreme examples like you just mentioned. So that's prohibited. Then you're at a high risk level. So high risk level is one level down. These are not prohibited, but those are systems where the legislator deems they're risky and they need to be subject to a more stringent set of rules. And it's mainly those that we're currently advising our clients on, because it's those high risk systems that will be subject to the majority of the provisions and have the biggest fines under the AI Act. And if you look at what those are, that's a more realistic list, I think, for a lot of companies. Whenever, for instance, I use the example of filtering CVs, that's a high-risk system. Whenever you use CVs to decide on employment or to decide on promotions, all that is qualified as being high risk.
Yeah.
The same education. My kids are too young to go to a university, but I've got a lot of people that have been at university a few times ago in my company. I mean, they all talk about the recent tools. For instance, the exams they did during COVID. A lot of those tools were kind of monitoring where you were looking at.
Yeah.
And on the basis of that, either disqualifying you or qualifying you for your exam. Those systems, in my interpretation, also qualify as high-risk AI systems. So there are a few systems that are more realistically used by companies. So the prohibited category, frankly, for most companies, that's not going to be a big issue. The high-risk category, I think that's where it matters for a lot of companies.
And these high-risk systems, are these mainly put in this category because they are very prone to be abused, to be abused by a government, criminals, companies, or are these high risk because they have the possibility to have very unwanted outcomes, like, for example, discrimination?
It's both.
It's both.
It's
okay.
both is the answer. I think the latter maybe more than the former. I think when that list was being drafted by the legislator, and again there were huge discussions around that, the key was really what is the impact if it goes wrong on the users, on the individuals.
Yeah.
The CV filtering is, I think, a very good example.
Yeah.
If a system is biased,
yeah.
You will disregard candidates that might be very qualified for the job, but that have a different skin color or a different ethnic background. That is really what the legislator was mainly looking at. There's a few high-risk systems where the risk of abuse, I think, is more important, but for the majority, it's really the impact if it goes wrong.
So obviously, most of the companies will not develop their own AI systems just because it costs a huge amount of money, and they will purchase the system of another company. Are they also affected by these laws and regulations with regards to the prohibited and high-risk systems? And how should they deal with this?
Yeah, that's an important question, because you're absolutely correct. If you look at what has been published about the European AI Act, it's often about the obligations that lie on the provider of the AI technology. But if you look at our client base, most of our clients are not developing their systems. Some are, but most are just licensing in third-party solutions that have been developed. And the short answer is yes. There are a number of obligations under the EU AI Act that apply directly to what's called a deployer. And a deployer is the company that implements a third-party system in its company. There's a couple of obligations that lie directly on them. To give a couple of examples, one of the obligations that lies directly on a deployer is the obligation to provide certain information to the end users. So if you use it for your employees, you'll have to inform your employees about the fact that you're using an AI system, what it can do, what the limitations are, etc. The other, I think, impactful obligation is that if you deploy a system, you need to have in place what's called human oversight, which basically means you need to have a team that understands how the system functions, monitors that system to see whether it leads to the intended outcome, and can stop it if it doesn't. So let's use that example of the filtering of CVs, because it's quite tangible. Suppose that you use a tool to filter CVs. It's a high-risk tool, but it's perfectly allowed if you comply with the different conditions. If you're a deployer, you license in a third-party filtering system, you deploy it in your company, you'll need to have a team that understands how does it come to the results. So it's not enough just to use it and trust the results. You need to have some understanding about how the system functions. So it can't be purely black box. You need to have some understanding. The team then needs to be trained to monitor the system and to look at the outcome, which means that at least you need to do certain, randomized tests. You can't trust always, for any, 100 amount of CVs you test, you need to look at some of the disregarded ones and see where they're actually correctly disregarded. Or is there, for instance, some bias in the system? And if you notice bias, you have an obligation to stop the system and talk to your provider and get it corrected. If you don't do that, you run the risk of being subject to the fines of the AI Act as a deployer. So not a provider? Not the provider as well, because they've produced a system that doesn't lead to the intended outcome. But as a user, if you had insufficient human oversight and you didn't sufficiently stop the system in time when you should have been aware there was an issue, you have your own responsibility in addition to the one of the provider. And it's important because I still see some clients assuming that just because they license in a system that's kind of hands-off. That's unfortunately not the case, which again brings us to the point that this should be a board level discussion, even if you don't develop the system, but you simply implement it.
Yeah, because if the fines are that large, it's a huge risk, and maybe you can say about the size of these
absolutely.
fines, how large will they be?
Fines can go up to 7% of the worldwide turnover of a company. I mean, just think that through. Think of a worldwide company active in multiple countries, 7% of turnover. That's not profit, it's turnover. That's gigantic. I mean, those fines we've seen previously in the GDPR. They're actually lower in the GDPR.
Yeah.
We've seen them in antitrust law. But this really, to my knowledge, is one of the recent European regulations with the highest possible fine. So I think it's quite key also for that reason to monitor this very closely.
Yeah, a lot of companies don't even have that profit margin of 7%. So it's
exactly. This really, and it's intended to harm a company. Now, those are maximum fines, of course, right? So I think in reality, in practice, at least early on, when things are still a bit unclear, there will be some kind of a grace period where the fines will be more lenient. But we've seen this with the GDPR in the past as well, with data protection law. I mean, there was this initial grace period where fines were more lenient, but now in recent years, we're often very, very much close to the maximum fine that can be levied. And I expect the same to happen for the AI Act. Initially, it's going to be more lenient, but after a while, you get closer and closer to that 7%. So the potential risk, it's intended to harm a company, but it can really actually harm a company if you get it wrong.
Okay, yeah, so companies need to watch out, especially the European ones, if I understood it correctly, because you already mentioned it, that Europe is pretty stringent in these laws, and that, for example, the UK and the US are pretty liberal on this, or am I wrong?
Yeah, no, absolutely, and that's, I mean, I mentioned the spider web metaphor, right?
Yeah.
And that's very much what it is. Every country has its own view. Europe is actually quite proud. You can discuss whether that's rightly or not, but they're quite proud of being the first big global jurisdiction to have this specific set of rules for AI. And it's true, because if you look around the world, there's not many other countries that have really taken the view of regulating stringently AI at the moment. Just looking around us, UK, they're quite liberal at the moment. They've taken very much a wait-and-see approach. They've got a white paper, but generally it's unregulated, and they're assuming that the existing rules are sufficient, at least now sufficient to deal with any real AI risk. So they've taken a very different view than Europe. The US, it's a bit fragmented. You've got some rules on a state level. You had an executive order. You have some more federal initiatives. But by and large, there's no overarching rule that governs AI there yet. And frankly, if you ask me, I would be doubtful if that came very quickly. A lot of the Asian countries, Singapore, for instance, has been quite vocal that they want to be more liberal to attract AI investment. So, I mean, you do see a lot of the other countries in the global world we are having taken a very different approach to what Europe has done, and at least for now, not having regulated AI yet.
And yet, it immediately kind of brings us to the strategic aspect, because if the EU has a very stringent law with regard to AI, will it hamper the innovativeness of our companies? Will it affect how we deal with new inventions and go forward and run our businesses?
Yeah, that's $1 million question, right? Or the €1 million question for now. It's very hard to give an answer to this at the moment, because it all will depend, I think, on how different countries will regulate AI and whether they will regulate it at all. The hope of the European legislator, and I actually spoke at length on this to Brando Benifei, one of the rapporteurs of the AI Act, just a few days before it was the political compromise was found. I mean, his view, he was a strong believer that it would actually help innovation, because it does give certain set of rules that companies know what they are, so it does give legal certainty. And his view was, once Europe has implemented this AI Act, what you'll see happening is that other countries across the world will follow that example, somewhat what we've seen with the GDPR. I mean, that has been followed by a number of countries. And he said, well, what will therefore happen is that Europe will be the first country to have legal certainty. Other countries will live, or other jurisdictions will live with this uncertainty for a period longer, and then they'll be hit with stringent rules. So we'll actually have, a head start on those other countries. I think it's an optimistic reading, personally. I'm more of a believer that I think these stringent rules at the moment are probably a bit premature. I mean, there's so much still evolving that I think it's risky at this moment to have this kind of definitive set of rules when we really don't know what the technology will bring us yet. And we've seen this already during the whole discussions on the AI Act. Initially, and I find this an interesting fact, initially nothing in the AI Act dealt with generative AI such as ChatGPT. It was simply not covered in the initial proposal back in 2021.
Yeah.
It was added actually quite late in the process because ChatGPT happened, created a whole hype. So, the legislator realized if we don't deal with that, then what's the value really of this piece of legislation? But a new ChatGPT can probably happen again next year, right? I mean, we don't know what AI will happen, what will be the next big evolution. So I think to have this set of rules, I think it's always good to have rules of the game, but I think it's very early to do that. And the big risk to me is that Europe ends up with this set of rules, other countries don't follow. And I think that's a real possibility. And then I think the answer almost has to be that, yes, it will hinder innovation in Europe because other countries will be more liberal, there will be less cost involved, there's less risk in terms of fines, and that will create more funding, more access potentially to talent of people that look for the most beneficial countries. So I think there is a real risk indeed.
And this risk will be mainly that we will not develop AI systems or that we will not use them, or both?
Well, I think you'll first see it in development. I think for any company, the upside of using AI, I think is going to be big enough to deal with whatever regulation you need to deal with. So I'm not that much worried about using AI. I'm more worried about the impact to a level of development of AI. And we actually have a few countries in Europe that are quite strong in it. France has a couple of good companies. Across Europe, there's a couple of pockets of strong AI developers. If you're an AI developer and you're faced with one jurisdiction where the cost is higher, you've got stringent rules that limit what you can do, and there's a risk of fines if you get it wrong, and you've got another country where that's not the case, I mean, the choice is not that difficult potentially to make in a global world like the one we live in. So I'm more worried for providers than I am for users at the moment.
Okay, yeah. Now, if we have talked a lot about the risks that are involved in AI, what can boards do to mitigate these risks for a company?
Yeah, no, that's important. I think, frankly, I mean, again, taking a step back, and I've mentioned it before, we have a lot of risks in Europe compared to other countries. But there's almost nothing that cannot be done. So I think engaging with AI probably is always worth the effort. But it's important to do it according to the rules of the game that exist today. And I think for boards, how you can mitigate that, I mean, the way that we look at it at A&O Shearman, and we've gone through this exercise ourselves for implementing our solution, we really try to look at it from 3 angles of risk mitigation. I think the first one, and that's probably the key one, is to look at the use case. And I think that's really key. How do you use your AI system? What do you use it for? And what is the whole governance around that? I mean, for instance, if you apply to what we've done as a law firm, we use it. We've clearly engaged with it, but we've got a clear governance also around it. We cannot use it to create any products for our clients. We use it to create input for us lawyers. And that needs to be double checked. It needs to be integrated by lawyer in whatever goes out to the client. So we've clearly limited the use case. We've put a clear governance, training, etc. around that so that we limit what we can do with it. And I think that's really probably the key part of risk mitigation. Think long and hard as a company what you want to use AI for, and think about what you probably shouldn't use it for, because at least today it's too risky. I think that's the first important risk mitigation. I think the second one that's much less legal, but it's equally important. It's anything dealing with operational and technical. That has to do with Where's your data kept? Who holds the key to your data? Is your data actually used to train the model, or is it excluded? Do you have your own fork of the AI system, or will you improve the system so that your competitors who license in the same system can get the benefit from your training data? So it's more around all the technical operational safeguards that you've put in place. And then I think the third, risk mitigation, and goes back to my core, that's all contract mitigation. If you license in, especially when you license in systems from a third-party provider, what does your contract say? What safeguards does it give you? What if there's an IP issue? Can you get an indemnity from the provider? Is there a liability of the provider? So to what extent can you, if you run into an issue, hold the provider liable for that? That's the third, the contract mitigation. And I think it's not either of those. It's not two of those. I think you need to hit all three of those to mitigate your risk sufficiently. But again, it can be done if you look at it holistically with those three risk mitigations in mind.
And should boards be open about the fact that if things go wrong, should they inform the authorities? Should they publish it somewhere in the annual reports? What would you recommend?
Yeah, that's difficult. It's a very tactical question, and it will depend per company, I guess. There's a couple of cases where you don't have the choice. If there's a real cyber incident, again, the AI Act, but also data protection law and some of the cybersecurity rules will require you to notify that within a certain time periods, which are not always consistent between regulations, but you've got a number of time periods you'll need to comply with to inform authorities, and in some cases inform the public. But assuming that doesn't apply, so assuming you don't have a legal obligation to notify, it becomes much more of a tactical question. I'm personally usually, not always, but usually a proponent of being more transparent. I think it creates confidence, and the risk of something leaking on, if it goes wrong is, I think, quite substantial, especially when you deal with AI, because a lot of the press is interested in that. So I think there's a real risk of leakage. So I would tend to favor transparency. But again, there might be some cases where transparency might not be appropriate. If you have certain obligations as a publicly listed company, or you're on the verge of concluding a major deal, you may make the tactical choice not to notify or to notify later. But generally, I think transparency is probably the better approach.
Yeah, I'm more practical than if something happens. Would you then also kind of say that an internal law, internal legal team? So, and then if things go wrong, would you then say that an internal legal team should have contact with outside counsel to deal with these things, or should this be done internally? Or
well, that's a hard question to ask a lawyer, of course. Yeah. Of course, everybody needs to consult their external lawyer, naturally. Yeah. I think the real answer is it depends on how big the issue is, really. We've seen sometimes that doing it internally has a risk if things evolve in a bad way. Suppose that a third party is involved, then you quickly get into discussions of liability or where was the fault. I think it's helpful to have either a big in-house team that can deal with it, or if the team is smaller, to involve external lawyers and to do that early on to avoid that you have to run behind things. But I think the bigger the issue and the bigger the potential liability, the more likely that you should, I think, involve external consultants or lawyers, yes.
So then if something happens, a board should immediately or very quickly look for help outside the firm?
If you run into real risk, real issue, yes, I would recommend to do that, absolutely. I think the risk of this, on the one hand, there's a PR issue, right? AI is hot, the press is jumping on any of these issues, and we've seen this time and time again. I think it's key that you get on top of it and that you take the right steps and that you can communicate that, just from a PR perspective. But then you have the fines that you need to deal with. Very often just mapping your obligations will be difficult because you have this patchwork of different obligations. We talked about the patchwork internationally, but just already looking at Belgium, if you have an AI system that will fall under the AI Act, it will fall under data protection law, it will fall under cybersecurity laws, there might be an IP issue, there might be an employment issue. Just already within Belgium, in that one small country, there's so many elements to that. I think either you've got a strong legal department that can handle that, or a very well-informed board, or I think help is appropriate in that scenario.
Okay, yeah. And maybe to conclude, would you recommend other things to a board to deal with the legal aspect of AI, or things that say, did you say these things boards should know definitely?
Well, I think, we talked about a lot that I think boards should know. I think maybe two key messages. I think, I again want to reiterate, I think it's really important for boards to be involved in this. This is not something that's just a legal issue, not at all. I mean, this is way wider. It involves, I think, all the different stakeholders. It needs to go up to the board because there's a couple of tactical choices. How much risk do you want to take? What use cases are you going to use it for? What's the risk level associated with that? I think it really needs to be a board level discussion. Then that's one. And then secondly, I spoke about the multiple moving targets. I think that's really important for the board to know. It's not enough to just make a decision and then stick with it. I mean, that works a lot for many, many different topics. It doesn't work for AI. It just moves too quickly in terms of technology and regulation. So I think for the board, one of the key messages as well to stay updated. Go to conferences, listen to this kind of podcast or wherever you get your information from. It moves very quickly. So make sure that you stay up to date because information from a month ago might not be information that you need anymore.
Yeah, okay. Yeah, and GUBERNA will obviously help board members to stay up to date with the help of Ellen and Over Shearman.
Absolutely, pleasure.
Okay, thank you very much, Peter, for this interesting webinar.
Thank you for having me.
Yeah, I think we can conclude that it will be a challenging time for boards to deal with AI, and that they really have to keep up to date about what happens, especially with regard to the EU AI Act and which litigation will evolve out of it. So I would also like to thank the audience for your attention. And for those keen to delve deeper into this topic, remember to explore other webinars on the theme of artificial intelligence and stay updated with the regular updates and papers published by GUBERNA. Thank you all once again.